1 o'clock to get started, and we're almost there. Here we go, it's 1 o'clock. Thank you everybody for joining. This is a session on COVID-19, immigration and employment. I am a immigration and global mobility partner at Spencer West. And my name's Samar Shams, and I'm delighted that my colleague, Fudia Smartt, is joining us today as well. She's a partner in our employment department, and she is absolutely fantastic, as you're about to discover. So we have a lot to get through today. I'll just start with some housekeeping items. So first of all, I would suggest using the side-by-side viewing mode so you can see both the speaker and the slides quite clearly during the presentation. To do so, you would go to your view options at the top right next to the green bar and select the side-by-side viewing mode. I also wanted to let you know that we'll be taking questions only through the question and answer function. That's at the control bar, which becomes visible if you hover your mouse towards the bottom of the screen. And if you see a question that you too would like answered, you can like it. Please don't ask questions in the chat. We're not going to be checking chat for questions as we go. But we do invite you to ask whatever questions you have as we go along. Again, as I said in my webinar last month, I love an interactive session, and Fudia does too. So we're happy to take questions as we go along. Although I'll also say that we have a huge amount of material to get through. So we need to be conscious of that as we go. We'll be using the polls function as we go to ask a few questions. And we might also ask you to raise your hands at certain points, which you can do by going to raise hand in the control bar. But again, if you have a question, just put it in the question and answer function. Okay. So in terms of what we're going to go over today, we'll talk about general immigration policies relating to COVID-19 that the government has published. I'm going to focus a bit on sponsored skilled workers, and then Fudia is going to run through the coronavirus job retention scheme. I'll then discuss how it relates to sponsored skilled workers. Fudia is going to talk about the HMRC online portal. Yeah. Then we'll talk about tricky issues both in employment whilst the pandemic's ongoing, as well as immigration. We'll talk about layoffs and short-time working and termination of migrant workers as well. And hopefully we'll have time for a bit of crystal ball gazing in section 7, entitled What Next? So we'll just go ahead and get started. So the first section is on COVID-19 general immigration policies, and I'll just preface this by saying that there's not a lot of detail in the policies given so far. In fact, 2 of the most prominent immigration barristers have submitted to Parliament that the guidance provided is unlawful because it's so uninformative, but we'll do the best we can today to explain what we do know. So there's a general policy allowing visa extensions for those migrants who are in the UK whose visas are expiring between 24th of January and 31st of May. They'll be able to extend until 31st of May 2020. And there have been various forms for this extension process over the past few weeks, various formats for doing this. Initially, it was by email. Now there's an online form that you submit, and the Home Office says that they aim to answer within 5 working days. The result would be a status letter or an extension letter, and it would confirm that your leave is extended under the same conditions as your current or expiring visa. And an employer can use this letter with the employer checking service on gov.uk to get confirmation from the government of rights to work in the UK. On the form, there's a text field where you're supposed to list your reason for being unable to return. Make sure to mention COVID-19 and the reasons given in the various guidance documents are border closures, self-isolation, or flight suspensions. Now, there's no way to actually submit documentation of any of those reasons, but I would suggest that you keep documentation of those reasons. So for example, PDF prints of flight searches or of border closure information on the internet. As per the status letter you'll receive, you would not be considered an overstayer. However, it's not clear that this extension process actually constitutes an application under the rules, which is significant because only an application will trigger what's called 3C leave. That's named after the relevant statute. And that is the legislative provision that allows the conditions of a migrant's leave to be extended whilst an application is pending. But it is clear, again, from the status letter that the conditions of your leave that you're extending are valid from the time you receive the status letter. And so it's likely that the Home Office at least intended that these submission of this type of online form will extend the current conditions of your leave. There's also a new policy in place during the pandemic allowing migrants to switch visa types. So that basically means that you wouldn't have to return to your country of origin to make an application, whereas otherwise for a lot of applications you would have to. Migrants aren't necessarily allowed to switch between different types of visas from within the UK. This special provision allows them to do so. However, it's only available to those whose leave is expiring before 31st of May, 2020. These are actual applications, so they definitely do extend the conditions of one's leave whilst the application is pending, including the right to work. Keep in mind that all other visa requirements still apply. So for example, if it's a tier 2 application that would otherwise require a restricted certificate of sponsorship, so certificates of sponsorship are the authorization to work in the UK. If it's the type of sponsorship matter that requires a sponsor to first request the restricted certificate allocation, they'll still have to do that. Now, in a previous version of this switching policy, the government explicitly said that tier 2 intra-company transfer migrants can switch to tier 2 general. So it's likely that that is one of the switches allowed, but it's not totally clear who's allowed to switch from what to what. So whether visitors are allowed to switch, etc. Unfortunately, to date, the government has provided very little overarching guidance. However, they are quite responsive on a case-by-case basis. So we can correspond with the Home Office to get an answer on a specific case, but to date, they haven't published a lot of guidance that's generally useful. We are expecting guidance to come out, and I was really hoping it would be ready in time for this webinar, but unfortunately, they haven't published it yet. Another general provision relating to immigration and COVID-19 is that right to work checks are now, employers can now do right to work checks by video conference. So the way it works is an employee would first provide an electronic copy of their right to work documentation to the employer, and then the employee would show the original document whilst on a video call with the employer. You can also use the electronic checking system. So that's for individuals with biometric residence permit cards or who have status under the EU settlement scheme. You can use a process by which the employee generates and then shares a share code with the employer so that the employer can access confirmation of the employee's work rights, employment rights online. Now you would still have to do a video conference afterwards. The employer should note that it was an adjusted check undertaken on whatever date due to COVID-19 when they do the check, and file that away. And the employer is going to have to recheck the documents using the normal right to work check processes within 8 weeks of termination of these COVID-19 right to work check provisions. We don't know when the termination of these provisions will be yet, so that's something you'd have to keep an eye on. Then you'd redo the check according to normal right to work check processes. I can advise on that if you'd like. And you would do the normal annotations on that. You might refer to the previous COVID-19 check as well. I'll talk a bit about high value migrants. And Jim, I don't know if you're on the webinar with us, but a friend of mine named Jim asked about whether there were particular effects on innovator migrants. Now, innovator migrants are one of a set of migrants that the Home Office deems high value, not terribly PC, but it basically means investors and entrepreneurs, people starting businesses. Now, there aren't a lot of policies that relate specifically to this group, but you know, all of the general policies that I'm describing and will describe later in the webinar as well, relating to interruptions to the visa application processes and the endorsements in passports, etc., those will apply equally to these high value migrants. In terms of specific guidance just for high value migrants, this is it. So they can access the coronavirus self-employment income support scheme. And the Home Office has said that where an applicant has received an endorsement for the innovator, the startup, or the global talent routes, those are all routes that require endorsements by various bodies or business support services, venture capitalists, accelerators, depending on the route, or universities for the startup visa, where they already have an endorsement, and it might expire because the applicant can't use it to support their visa in time because they can't travel due to the coronavirus. The Home Office will still consider those applications, but again, it will be on a case-by-case basis, so it's not a sure thing that you'll still be able to use an expired endorsement. I imagine there's going to be, you know, some kind of end date after which they're not going to be accepting them, but we don't know yet. The other concession is for Tier 1 entrepreneur migrants. So you might be familiar with the job creation requirement, that you create 2 jobs, the equivalent of 2 full-time jobs for 12 consecutive months. So the months no longer have to be consecutive. However, time on furlough will not count towards the 12-month requirements if, because of COVID-19 and furloughing, or laying people off, you won't be able to meet the requirements for extensions or for indefinite leave to remain as a Tier 1 entrepreneur. There is a process by which you can extend just to be able to meet those requirements as well. That's another aspect of the concession. So I'd like to take a minute to ask you a question now via the poll function. So, true or false? Tier 2 and high value migrants can access public funds in the UK. If you would take a minute to vote according to what you think the answer is. Okay, so, oh, answer's still coming in. True or false, Tier 2 and high value migrants can access public funds in the UK. Okay, so I'm going to go ahead with the results that are in now, where 79% of people answered false and 21% answered true. It's a bit of a trick question, I'm sorry. It is false. So although high-value migrants can access the coronavirus self-employment income support scheme, and Tier 2 migrants can benefit from the coronavirus job retention scheme, those do not count as public funds, and neither of those groups of migrants can access public funds. So with no further ado, I'm going to turn you over to, oh, sorry, no, actually, I'm going to talk to you about sponsored skilled workers first. Just a little bit more, if you'll bear with me, and then I'll turn you over to Fudia for an overview of the job retention scheme. So I'll talk a bit about sponsored skilled workers now, but I'm also going to address some of the issues relating to them, throughout the rest of the session as well. So if I don't answer your questions now, maybe hold on. So for example, Shafina, you asked a really good question about what wording to put in a report when you're furloughing people, and I'll get to that after Fudia explains the job retention scheme. So there's a new policy in place just in relation to COVID-19, where if somebody submits the online Tier 2 application form, they can go ahead and start working for the employer. So any employers watching who might have previously supported a Tier 4 student migrant in switching into Tier 2, they might know that there is a concession for those migrants to be able to start work from the date the Tier 2 application is submitted, the online application, and that is the case now for Tier 2 applications generally during the COVID-19 restrictions on movement. And that's because the UK visa application centres, where people submit their biometric data as a later part of the process, well, they're all closed. So there's no way of completing the application process at the moment. And so the Home Office is allowing employees to start working from the date of the online submission of the application. Now, I would use this concession with caution. Again, we don't have a lot of details. I feel happy, safe using it for existing employees who are maybe changing roles, certainly for extensions. But if you have somebody who's switching from a different immigration category, then I would proceed with caution and maybe get advice on a case-by-case basis for those matters. In any case, if you are able to take advantage of this concession, you'll have to have assigned a certificate of sponsorship, and the employee will have to have submitted their online application before the expiry of their current visa. Then they'll be able to work as authorized in that certificate of sponsorship, and only as authorized in that certificate of sponsorship. Reporting and record keeping duties kick in from the date the certificate of sponsorship is assigned. And if the Tier 2 application is eventually refused, then you're going to have to terminate that individual. In terms of start date delays, now anybody who has ever entered a start date on a certificate of sponsorship will know that it's a horrendous experience trying to figure out the relevant start date. And so coronavirus has not made it easier. So the Home Office has granted some indications of its general pragmatic stance. It's saying it will take a pragmatic view of these types of applications. Basically, if the certificate of sponsorship or cause has expired, or if the start date has passed, they will still consider these applications on a case-by-case basis. You would definitely have to state that the inability to travel, which has led to the cause expiring or the start date passing, was due to COVID-19. And if you do so, the Home Office has said, they will take a pragmatic view and they may allow the application. Now, keep in mind that a sponsor can and should change the start date on a certificate of sponsorship before assigning it. I thought it'd be helpful to look at a timeline together to understand exactly what the effect of this concession is. So this is a non-COVID-19 timeline in a tier 2 matter. So you'll see from the time the cause is assigned, there's 3 months, and the applicant has to submit their application, their online application form, within those 3 months. Otherwise, the cause will, quote unquote, expire, okay? So this is one point at which the concession helps. Where a cause has expired, the applicant might still be able to submit the application. Now, the other point at which it might help is if the start date has passed. So you'll see again, you can submit an application up to 3 months before a start date, the start date on the certificate of sponsorship. So another place where the concession would help is that maybe applicants can submit their applications after the start date has passed. And there might also be pragmatic approaches taken by the Home Office in relation to the 28-day maximum on delays to start dates once the visa is granted. So that's a very complicated aspect of the sponsorship system. So it doesn't help that it's being messed around with by COVID-19. And I'll discuss the temporary vignettes a little later in the presentation, but I'd like to just do a quick quiz to check understanding of this point. So how many people, let me make sure you guys can raise your hands. How many people think, yeah, you can raise your hands. So how many people think the start date, when you assign the cause, that the start date has to be within 3 months? Raise your hands. Okay, we've got a few people there. And how many people think when you assign the certificate of sponsorship, the start date has to be within 6 months of when you assign the certificate of sponsorship? Yeah, okay, so we got slightly more people raising their hand for the second option. And that's the correct answer, in fact. So this is a point that actually there's a lot of misinformation put out, unfortunately, some of it by immigration practitioners. There's a misunderstanding that the start date has to be within 3 months of assigning the cause. That's not the case. It can be up to 6 months because you have 3 months between when you assign the cause and submit the application, and then 3 months again once you submit the application to when the start date has to be. Okay, I'll quickly run through absences. Sponsors now do not have to report authorized absences if they're due to coronavirus. Again, it's always worth keeping documentation on file. It's unfortunate, but I just don't trust the Home Office. So I would advise you to just document all the decisions you're making. It's going to help tremendously, I'm sure, if you ever get visited by the compliance team, the sponsor compliance officers. The other thing is that sponsors no longer have to terminate sponsorship after 4 weeks unpaid leave. So the normal rule is that a sponsored skilled worker who's absent for 4 weeks or more in total over a calendar year, according to their normal working pattern, they then have to be terminated by their sponsor. Sponsorship cannot continue if there's more than 4 weeks unpaid leave. So the concession, the COVID-19 concession, is that the sponsor doesn't have to terminate them. Now, the government published Tier 4 guidance a few days ago, which included this intention to resume requirement for an analogous provision for students. We're still waiting on the on that similar type of guidance for tier 2 sponsors, and it might have the same wording about the worker, the employee, or perhaps the employer intending for the employment to resume in order to take advantage of this concession. At the moment, that wording is not included in the information published by the government. Okay, reporting requirements that do still apply are insolvencies. So unfortunately, a lot of businesses are going out of business, and that's a change to the corporate structure that still needs to be reported. However, reporting homeworking due to COVID-19 is not required. It is best practice to document homeworking, and in particular, if it's just due to the pandemic, make sure it's on your own files at least. Okay, I don't want to take too much time. Fudia, may I pass to you for an overview?
Yes, please. Hello, everyone. Samar, I may still need you to move the slides because I feel scared.
Okay.
I've realized I'm a Zoom Luddite for the uninitiated. But unless you've been hiding under a rock, you will have heard the term Coronavirus Job Retention Scheme, or CJRS as it's commonly called. We're just going to look at some of the details to the CJRS. It was introduced on the 20th of March, and its aim was clearly to try and reduce the risk of having to make mass redundancies that would have clearly pushed us into a recession, if not a depression. And it brought about the concept of furloughing, a term which I understand originates from the military, but had never been used in employment law before. And it's this idea of having staff who are ready and available to work, but who will not be working for you. And the government is going to subsidise up to 80% of wages, or up to $2,500 per month gross, and inclusive of the employer's NICs. Now, just about what you can pay in respect of wages, it covers everything bar kind of discretionary bonuses, commission, and non-cash benefits. Employers can but are not obligated to top up that amount, but they will therefore need an agreement with the employee if they're only going to pay the $2,500 capped amount. Now, there was a big worry on Monday when the HMRC portal went live where it said you needed a written agreement, and for employers who were going to top up, they perhaps didn't bother getting a written agreement. And the guidance now coming from HMRC, or I should say from the government, and I'll explain the difference between the two, is that that is fine, as long as it's clear that there's something in writing that the employee was going to be furloughed. You didn't need them to expressly agree to it in return. One of the big things, and I think this is what HMRC is going to be reviewing very carefully in years to come, is that employees on furlough cannot do any work. And in fact, I should use the term worker. For those who don't know, in UK employment law, there are 3 categories of staff. There are employees who have the greatest rights and obligations, an intermediary class known as workers, and then the genuinely self-employed. And under the CJRS, those who are paid via payroll can be covered. So that includes workers as well as employees. But I'll use the terms interchangeably. Now, as you'll see, there have been 4 iterations of guidance, and that's basically because the government has never had to, Parliament produces legislation which usually takes a year minimum to get on the statute books, and they did this in a few weeks. And so with speed comes error, and there are lots of areas of ambiguity which are keeping nerdy employment lawyers such as myself readily checking all the different rules. The government has created a website, which I've given the link there, to try and help people navigate this. But the difficulty is caused primarily because they didn't have time to think about all the various permutations, such as holiday pay, sick pay, what to do with people on maternity leave, if you've taken a business over, what happens for the transferred employees, etc. And the guidance has tried to mop up those areas. But the other issue is that HMRC is going to be responsible for payment and management of the scheme. And HMRC will be led by Treasury directions as to how to follow. And unfortunately, there are discrepancies between the Treasury direction and the guidance that the government has been putting on their website. And what we've been told is that the Treasury directions will take precedence, which obviously creates a real panic for people, because if you've been following the government guidance, and it turns out that there's a discrepancy that's not in your favour, that's going to be a cause of concern. Now, what commentators are saying, what HMRC has said, is that it will follow the guidance, which then begs the question, why is there a difference between the guidance and the direction? So only time will tell how they resolve that. The scheme can be backdated to the 1st of March and is open now until at least the end of June. Now, again, with this query about backdating, if there's a requirement for a written agreement as per the Treasury agreement, or at least something in writing telling staff you were essentially requiring them not to attend work, many will not have anything in writing at that date. So again, a question mark as to how you can backdate before the scheme was even in contemplation. But again, we'll have to wait and see. The scheme went live on the 20th of April, and word on the street from my sources is that some employers have already been paid. So they had said it was going to take 6 working days, and in fact, on the first day, apparently 100,000 different employers applied, and some of those have already been paid. So it seems that they are honouring that. And what I suspect is that the HMRC is going to take a pay first, challenge later approach to this, because the fact that they've been able to build a website in such a short period of time is a marvel in of itself. And they clearly won't have the time to trawl through all of the employers' documentations to make sure there's something in writing, that staff weren't doing work. So I see this being a ready source of litigation and disputes with the HMRC for years to come. Now, an employer could seek to put workers and employees on the CJRS scheme if they were on their payroll, paid via PAYE, and they were on the real-time information that you have to submit about employees for payroll purposes on or before the 19th of March. They've removed this cut-off date of the 28th of February 2020 because, to be honest with you, it created such angst. I remember when the Chancellor said that some people would be left behind, and those people got ready with their government-led petitions, etc. And so now there's this kind of lacuna where if you were dismissed around the 28th of February or you resigned, your former employer can rehire you. The Treasury direction says on the basis that your employment terminated before the 19th of March, but there is some ambiguity as to whether you actually have had to have been terminated before then. So I think that could include where you've been put under notice and you were due to terminate. So employers are, and in my experience, have been putting staff they've put on notice on furlough, staff that they had selected for redundancy on furlough, and where people were dismissed or resigned pre the 28th of February are putting them back on their systems. Now that causes its own headaches because when you rehire someone, there's nothing to suggest in the scheme rules that all the other employment rights that they're entitled to would cease. And again, if there isn't a break of 1 week's service between when their employment terminated and you hire them under this new fixed term contract, you could be giving people unfair dismissal rights, which they may not have had because of a lack of length of service. So again, I see all of that being a ready source of litigation. What I would say is that employers are not under no obligation to agree to furlough anyone, and particularly in relation to former employees. So I see this being on a goodwill basis. It does cover those who work part-time, fixed-term, apprentices, and those on 0-hour contracts. Interestingly, and made clear in the 4th of April guidance, it also covers others that you wouldn't readily consider being employees or workers, such as office holders, directors, salaried members of LLPs who get paid via payroll, and agency workers. And I think this is in keeping with the spirit behind the scheme, which is to not leave any man, woman, or child behind, and to ensure as many people as possible can get access to having most of their salary covered, or at least a fairly large percentage.
We're not condoning child labor.
No, we're not. And I think that's an important note there. Thank you, Samar. Although my daughter is in the garden at the moment doing some weeding. HMRC, because it falls within their territory, it's their test for determining who is an employee, not the Employment Rights Act test. Now, for the HR employment nerds amongst you, you may or may not know that it's possible under our current system for HMRC to determine someone's an employee, not employee, they're self-employed, but for the employment tribunals to determine they are an employee. And again, that causes headache. And I think that's why the Treasury is taking ownership of this, because it's really the tax question, are they on your payroll or not? Now, just as a side note for people to take into consideration, although directors can be furloughed, they will still have certain duties they will need to comply with. Their fiduciary duties, for example, to ensure they're acting in the company's best interests. So while there's this tension of not doing any work, I think what will need to happen is that will have to be relaxed in relation to directors, particularly if your business, let's say, is facing insolvency. You just can't say, slope your shoulders, sorry, I'm furloughed, I can't do anything, because you still have your duty to act in the best interest of the company. I would recommend, if you are in that situation or advising, that you get employment and corporate advice and let everything be accurately and correctly recorded in your board minutes. Now, the furlough leave is set to be for a minimum of 3 weeks. Most commentators are suggesting that you can probably rotate your furlough employees. So if for 3 weeks you want to furlough a particular division, and then the next 3 weeks you furlough a different division, that should be possible. I say should because with all of this, there's a lot that isn't answered. And again, the guidance isn't the key determining factor, it's the Treasury directions. Non-UK nationals can be furloughed by a UK employer, and I'm sure Samar will have comments on this. It's not deemed to be access to the public funds, as she suggested earlier. It's a very bespoke, unique situation, and even though it's the government covering the bill, they're not seeing it as the same as claiming usual benefits. All categories of employees on visas can be furloughed, and you can be furloughed for more than one job, and you can therefore receive up to the 2,500 cap per month for each role. Now, I've had lots of discussions with other employment lawyers of would it be deemed an unfair dismissal if you refuse to consider furloughing a member of staff as opposed to making them redundant? And according to the guidance, it shouldn't, I would say, because you do not have to furlough. It's not an obligation on an employer. It's something they can take into consideration. I say it shouldn't because there's always the risk of people arguing, for example, discrimination. If, let's say, you've agreed to the request to furlough men in those circumstances or not women, or, you know, has a disproportionate impact on people of color, etc. So I would say it's one of those things that, although you don't have to do, it'd be worthwhile documenting the reasons for not doing so and being able to justify them. Government guidance is suggesting there's still a need to collectively consult. And this is unfortunate because under the Trade Union Labour Relations Consolidation Act, or TORICA as most of us call it, where an employer is proposing to dismiss 20 or more within a 90-day rolling period, they are required to collectively consult. And that involves notifying the employees that they're at risk of redundancy and allowing them to appoint representatives to consult on their behalf. And depending on how many people are affected, it could be a 30 or 45-day consultation period before you can kind of commence with making any redundancies or dismissals. The legal position with sickness and furloughing, I've signposted, but I would take up the remaining time trying to dissect. But it seems that if a furloughed employee becomes unwell, then they should be receiving statutory sick pay as opposed to the furlough pay. But then the question is, as the furlough leave has to be for a minimum of 3 weeks, what happens if somebody's 2 weeks and 4 days into it and then becomes sick? Will you not be able to claim back the furlough pay because you've breached the 3-week minimum requirement? And I'm sure the latest iteration of guidance will clarify that, but I think that cannot be right. But I think what's going to happen most likely in practice is that employees will just not notify their employer that they're unwell. Because why would you agree to take statutory sick pay, which is a significantly reduced amount of a few £100s a week, as opposed to getting up to £2,500 per month gross?
Okay, so Fudia, did you get to say everything you were?
Yes, please.
Okay. Before I launch into furloughing sponsored workers, I just want to remind people that you're welcome to ask questions as we go along via the
yes,
question and
please.
answer function, which you will find if you hover over the control bar. So please do submit questions as we go along if you have questions. Fudia, did you want to poll people?
Oh yes,
We'll run a poll now as well.
Thank you for reminding me. It's my fear of touching the controls, but we do have a question, because I know it can be quite difficult to take on these concepts, particularly on a webinar. And yes, please do ask questions, because I know that there's a lot of information out there.
Okay, we finished that one. Oh, here we go. Ooh. Oh, here we are. Okay, so quiz time. Fudia, can you see that? Do you want to read it out?
Yes, I can.
Yeah.
True or false, ladies and gentlemen, in complying with the coronavirus job retention scheme rules, Treasury direction supersedes government published guidance?
Okay. All right. I think les jeux sont faits, as they say in French.
I think, or as they say in America, that's a slam dunk, that everyone seems to have accurately. Oh, we've got a raised hand.
Do you have a question, Katya? Can you put it in the question and answer function, if that's okay, Katya? All right. Do you want to discuss the results, Fudia?
Yeah, so just to add a bit, I think we've got a clear leader. Everyone's saying yes, it's the Treasury directions when it comes to complying with the CJRS. Now, I should add some colour to that. Now, the Treasury said that they will look at the published guidance in how they go about. Oh, we've just had a clarity on the raised hand. The government guidance has said Treasury said they'll look at the guidance in how they actually implement it, but in order of authority on dealing with payments under the scheme, it's the Treasury directions first and then the government guidance.
Great. Okay, I seem to have gone way ahead in the slides. Okay, let's talk about furloughing sponsored skilled workers. So employers can benefit from the coronavirus job retention scheme when furloughing tier 2 migrants. Now, it's important though to keep in mind that this there is a permission, a concession to reduce tier 2 salaries to the lower of 80% of one's salary or 2,500, whichever is lower. And so that matches exactly the salary reductions allowed under the furlough scheme. But when it comes to tier 2 migrants, it doesn't necessarily have to be part of a furlough scheme. You can simply be reducing salaries without furloughing people. So it can be a simple salary reduction. And the Home Office has not clarified or has not stated categorically that this concession constitutes an exemption from the minimum salary requirements. So the sponsors amongst you will know that there are very strict salary requirements that have to be honored when you're sponsoring a migrant worker. And the Home Office hasn't said that, you know, if 80% of the salary is lower than that salary requirement, then you can still use the 80% salary level. But it does seem that that was their intention. It's also the case that the concession wouldn't really make sense if you're not allowed to go below the minimum salary requirements. So it's not totally clear, but I would say that, you know, that is part of the concession, that you can go below the minimum salary requirements if 80% of the salary or 2,500, whichever is lower, takes you below the salary threshold. It does mean that the first thing one should do when reducing the salary of a tier 2 sponsored worker is do this calculation of 80% salary or 2,500 and determine whether that takes you below the salary threshold required for that migrant, which will be the higher of the subcategory threshold, so 30,000 for Tier 2 general or 41,500 for Tier 2 intra-company transfer, the higher of that, or the job-specific salary threshold for that migrant. Because if it doesn't take you below the minimum salary threshold, then it still needs to be reported, but it doesn't really relate to furloughing or this program necessarily at all. It could just be like a normal salary reduction as if COVID-19 weren't happening. So that's the first thing to do. But if you are, and again, I think Shafina had this question, if you are reducing the salary below the minimum salary thresholds, then the wording that you use in the when reporting the salary reduction is quite important. So you should definitely include the reduced salary amount and the period of reduction. And when you are deciding the period during which the reduction will be in place, consider whether you are going to be trying to claim the funds from the government or not. And if you are, then you should abide by those restrictions on duration that Fudia described. I see we have a question. I'll just finish what's required with the reporting when you're reporting salary reductions before getting to it. You should also include in the report that the salary reduction is part of company-wide policies to avoid redundancies and that all workers are treated the same. Basically ticking those boxes for the UK Home Office caseworker to permit it and to see it as compliant. All right, let's see what this question is. Would you advise if an applicant's Tier 2 entry clearance has been granted, but he or she cannot enter the UK and commence their employment within the 28-day period, asks Muhammad. So there's no guarantee in this situation, but basically the Home Office has said they will take a pragmatic approach. And I'll talk a bit later about extensions of the 30-day vignettes. And Shafina's asking, do we also need to inform them that we're topping up the remaining 20%, so then there will be no salary reduction? I think, yes, whatever, providing more information is better. So I think that's, yes, I would include that information. Okay, so I hope that's all clear. Unfortunately, there's not a definitive answer to your question, Mohammed. We're at the mercy of the Home Office a bit. In that case, they've said they'd consider it on a case-by-case basis, and they'll take a pragmatic approach. They haven't yet granted a blanket concession in these cases, but they are fairly responsive on a case-by-case basis. So that's what I would suggest doing, is corresponding with them on that particular case. Okay, Fudia is now going to talk about the online portal, which I'm sure everybody's interested in knowing how to use.
Thank you, Samar. I imagine that all of you are kind of sick to death about the topic and the theory behind it. So I thought a practical examination about using the portal would be helpful. So as I said earlier, it went live on Monday, and there is guidance, and I can provide a link to people later, if that would be helpful, that the government has produced, as well as a YouTube video, if you fancy watching that, about actually how to use the portal. There is certain information that you definitely will need. It's on the next slide. You will need.
So you're
controlling it?
Yeah, there you go.
You will need the RTI submissions for all staff who are on your payroll before the March date, the 19th. Your bank account number and sort code, PAYE reference numbers, the number of exact people being furloughed with all of their national insurance numbers, and each of their payroll and employee numbers, which is optional, but I think the more information you give them, the quicker your application will be dealt with. The start and end date of the claim, and the full amount that you are requesting, along with all your contact information. You also need to put the company's name down, the corporation tax unique reference code and your self-assessment, as well as the company registration number. And after that, you'll get a reference number. And if approved, it should be in your bank account via BACS transfer within 6 working days. The advice I'm giving to everyone is to make sure you print off the claim acceptance, print screen, so you have your number, because you may need that if there is a delay in the application. And also try and have all the paperwork needed in case you do get a query from HMRC, not only the numbers listed above, but the exact start dates when you want the furlough leave to have started from and the proposed end date. Now, I imagine lots of employers will be saying until the end of June. The scheme could be extended, and I think all of us are going to have to wait and see as to how the infection rates happen over the next few weeks, as to whether we think it likely or not the government will do so. The other thing I would go back to the point I made earlier. If you've got people that you may want to dismiss them by notice, so that the whole notice pay is covered by the furlough, I think you should be reviewing this on a kind of week-by-week basis. The reason I say that, if at the end of June, you can no longer afford to pay these people in the event that HMRC has agreed to cover salaries, you will then be required to pay them their usual notice pay. And if financially you cannot afford that, you may want to serve notice earlier and use as much of the furlough period to cover their notice pay for that period. Does that make sense? If anyone has questions about that, please do shout.
Any questions? All right, let's go on to tricky issues. So Fudia and I are big nerds, and we love tricky issues, so we're pretty excited about this part. Do you want to take us away on holiday?
Please. So as I mentioned earlier, the issue with holidays has been that when the concept of furlough leave was created, people didn't understand how that would affect your right to holiday. So was it analogous to something like maternity leave, where you're entitled to all your usual terms and conditions, save for remuneration, but you still accrue annual leave? Or was it akin to a different type of leave, like sabbatical or sickness? Now, the difficulty is with most types of leave, you are entitled to accrue your annual leave. And the problem for employers is that the guidance that has come out is that employees, you cannot insist that all of the leave be taken during the furlough leave period. You still have to comply with the working time regulations, which means giving notice if you want them to take some of that leave. Now, the notice provisions under the working time regulations require that an employer give twice the amount of notice for the leave it wants someone to take. So if you wanted an employee to take a week's holiday, you'd need to give them 2 weeks' notice. But there's a whole issue of the fact that we don't get all of our holiday in one lump sum. You accrue it over the year. And some people are saying, well, would it really be in keeping with trust and confidence to require me to take annual leave during this period when I can't go anywhere? So it created all of these kinds of issues. What's happened now is that they've created extension regulation to say that people can carry their annual leave into the next 1 or 2 holiday years. Now that's quite a big concession, because usually if you only receive the statutory minimum annual leave entitlement of 28 days, including the 8 bank holidays, you cannot carry forward any of that leave entitlement. When you get beyond that, you can agree to carry normally 5 days or so into the next leave year, but they've relaxed that because they recognise it may not be reasonably foreseeable for people to take annual leave. Query whether or not what they really mean by reasonably practicable, because employers are saying, well, you're not going anywhere, so why can't you take the annual leave? But it's obviously creating a tension of good industrial practice about forcing people to kind of use their leave in these circumstances. Now, the difficulty with that is if you do require a member of staff to take annual leave, or people do request to use some of their annual leave during a furlough period, they will be entitled to their usual salary for that. And many employers are in a position where they're saying, we can't afford to pay that. That's the whole reason why we're furloughing you in the first place. So it's left this really weird tension where some employers, particularly for people who earn less than the 2,500 cap gross, may want to try and request for staff to take as much of their leave as possible, so that at the end of this period they haven't accrued a whole big amount of annual leave for which they'll be entitled to take or receive payment. But equally, if you cannot afford to pay people for the annual leave, you'll be trying to dissuade employees to take holiday. Now, I think this could be an area for litigation about how holiday leave is dealt with. But I don't see that being an immediate issue. I think most employees will be grateful for the furloughing arrangements and will not want to upset the apple cart, particularly as an employer after that first tranche of 3 weeks could then say, okay, we're not furloughing you anymore, arrivederci. So I don't see it being something that's going to happen immediately, but there's an inconsistency there with the law.
Okay, let's talk about tricky issues in immigration. One tricky issue is the expiration of temporary vignettes. So for most long-term visas in the UK, when somebody applies from overseas, they don't get the visa that documents their the whole duration of the period they're allowed to reside and work, if relevant, in the UK, endorsed into their passport. What they get is a what's called a temporary vignette, and it's a visa that's valid for 30 days only. And it just enables the person to come to the UK, to travel to the UK. And if, for example, they're a sponsored skilled worker, then once they're here, they would, they could use that as part of the right to work checks, but they still have to collect a biometric residence permit or BRP card, which is the more long-term documentation of their leave in the UK. So what's happening now, the 30-day validities of these temporary vignettes are expiring. And normally you would have to reapply if your temporary vignette has expired. And that's what the Home Office was telling people to do for many weeks whilst, at the beginning of lockdown. Now, on a case-by-case basis, they're suggesting that these temporary vignettes will be automatically extended. They've also promised to publish guidance on this point this week. I was really hoping it would come out before this webinar, but it hasn't yet. But basically, immigration lawyers are expecting a policy allowing for an automatic extension of these expired vignettes. Now, obviously, that's progress. That's a great step towards people being able to travel. But what do you tell the airline, when you're presenting them with this expired visa? So there's still that issue. I mean, basically, the Home Office can provide a reassurance to the airlines, but it's still wouldn't be an ideal situation. And there might be a different policy for people who require a visa to travel to the UK, for any purposes, and people who don't, so visa and non-visa nationals. We'll see. The other tricky issue that's not resolved is the effect on settlement in the UK and on citizenship applications of absences caused by people being stuck overseas due to COVID-19. So normally after 5 years in the UK in most visa categories, a migrant might be eligible to apply for settlement, but there's this limit of 180 days in any rolling 12-month period that you're allowed to be absent from the UK. So we don't know what's going to happen in relation to that. Will the pandemic be considered a serious and compelling reason? There are indications that it would be, and certainly it seems like it would be, but it's not a sure thing yet, unfortunately, and we'd love some guidance on that. Another issue is that visitors are stuck wherever they are on visas, and their employers, as time wears on, will be expecting them to be working remotely just like everybody else. But that's a big no-no. You're not allowed to work on a visitor visa. And in fact, you could be banned from the UK for up to 1 year for doing so. But by which I mean that you'd be ineligible for most visa types in the UK. There are some that you would still be eligible for, so some family-based visas, but otherwise a 1-year ban applies. You're not eligible to apply for a visa again for the UK for 12 months because you've breached the conditions of your previous visitor visa by working. There's also the problem of cooling off. Now, this sounds like a chillax kind of policy, but it's not. Unfortunately, cooling off applies to sponsored skilled migrants. And basically what happens is if you leave the UK and your sponsorship terminates, you're not eligible to return as a tier 2 migrant for 12 months from the date that you left. So what happens if a tier 2 migrant is now stuck overseas and their leave expires? Cooling off is going to kick in, and it might also kick in where you would otherwise be able to avail yourself of the switching provisions, the switching concession for COVID-19. So we'll quickly run through layoffs and short-time working. I'm aware that we're now at 2 p.m. We won't be offended if you leave, and we'll circulate the slides later.
For sure.
But if you are able to stay for this discussion, please do.
I'll try and rattle through this as quickly as possible. And apologies if I've been speaking double time, I'm just been conscious of the time. But in short shrift, layoff and short-time working was very popular pre-1980s, particularly for manufacturing, where sometimes work levels would dip and they therefore employees needed an ability to offload staff at minimal cost. Layoff is where you provide no work or pay, and short time is where you reduce hours and therefore correspondingly pay. And in order to rely on these provisions which are set out in statute, it needs to be set out in the employee's contract.
Just see what this question is. Oksana, I'll get to your question after we get through the main part of the presentation, if that's okay, just because we're short on time. Thank you. Go ahead, Fudia.
Sorry, so just next slide, please. Following the banking crisis, they did become more popular. And in these circumstances, where somebody is laid off, they can receive a guarantee payment for up to 5 workless days, capped at the princely sum of £30 per day. And it's only available where staff have been continuously employed for a month. But staff who have no work because they were laid off due to industrial action cannot claim the guarantee payment. Now, where an employee has been on short-time working or been laid off with no work or pay for 4 or more weeks in a row, or 6 or more weeks in a 13-week period, 3 of them which have been consecutive, they're entitled to write to their employer and basically ask to be made redundant. And they have a 7-day period in which to put that forward, and the employer has the options of either accepting it or putting forward a counter notice. In that counter notice, if the employer says, I will have work for you, you have a reasonable expectation that I can give you work within 4 to 13 weeks, then they can, the layoff period can continue. However, if they can't give that reassurance, or they withdraw their counter notice because the decision changes, then the employee must resign with notice, and then they'll be entitled to a redundancy payment. Alternatively, if the employer fights it, the tribunal will then make a determination, and if the determination is that they should be made redundant, the employee will then resign and claim the sum for redundancy.
Okay, definitely if you're considering short-time working for a sponsored employee, seek advice before you do so, because you might fall foul of sponsorship requirements. If you are terminating a sponsored employee, you'll have to report that within 10 working days to the Home Office. Their visa duration will be shortened, so the Home Office will write to them and shorten their visa to 60 days from the date of that letter. It's just something to be aware of. And again, they don't have access to public funds if they're laid off. So we have a few thoughts about what's next, but I think we'll just take a few questions now before getting into that, if that's all right. So going back to Oksana's question, Oksana has asked, a person qualifies for settlement under the ancestry category. The application is ready to submit, but they can't go to biometrics. What to do? So as of today, I would say that you'd have to correspond with the Home Office on this case. I would go ahead and submit the online application just to lodge that. The Home Office is aware, obviously, that the visa centers are closed. So I would go ahead and do that and then correspond with the Home Office as necessary about what to do. People who had scheduled appointments are now being given rescheduled appointments So, you know, it's not that you'll never get to submit biometrics. So I would go ahead and submit the application if you're ready to do so. Okay, do we have any other questions? All right. Yes. Can an employee be dismissed during furlough? Fudia.
Yeah, you can be. There's nothing to suggest. Thank you, Katia, for joining. There's nothing to suggest you can't be dismissed during furlough. So yes, you can be. The question would be, unless somebody, I can't really see why you'd want to, because they're not working and you're not paying for them. But there may be circumstances where it's, let's say someone's going to get 2 years of service and you want to avoid that, then yes, you could. The only thing to bear in mind is that they have to have been on furlough for at least 3 weeks to comply with the requirements to receive the reimbursement, the grant from the government. So you need to make sure you don't fall foul of that.
Okay, any other questions? All right, we'll just discuss some of these future-looking topics that interest us. But again, we're aware we've run over. Please do not hesitate to leave if you need to. You know, we will not be offended.
Thank you for sticking with us.
Do you want to kick this off?
Yeah, I mean, this is the kind of the Mystic Meg crystal ball gazing section, I guess, but I think it unlikely that the government will extend the scheme beyond the end of June. And that is one, everyone's scared about keeping everybody on lockdown until September for the economic repercussions, and also because the cold and flu season restarts in September, and there's a concern that people have kind of been sheltered away, that it might make the second wave even worse. So I think there will be a slow return to normality end of June, beginning of July. And I think at that point, once employers are no longer kind of propped up by the CJRS scheme, that they'll be making lots of redundancies, unfortunately. So I think a lot of businesses won't be able to survive going beyond that. And that in turn makes me think that a recession is likely. I mean, just looking at myself anecdotally, I doubt that I'll be going to restaurants and the shopping centres and all of that immediately when they say we can go out. I think there'll be a slow trickle. And lots of businesses that, you know, are kind of consumer based, unless they can remove the need for proximity of person to person, are likely to not be able to sustain that. What do you think, Samar?
Yeah, I would agree. And I think it segues nicely into the next point, which is the likelihood of a recession. Because, you know, even when the restrictions on movement are lifted, these businesses might not have a market, you know, even if they have managed to remain solvent.
Yeah.
They might not have a market to sell into still because of, you know, the slow lifting of the requirements and people's spending power at that time. So definitely recession is likely. I think that some of the figures I've seen, some of the predictions I've seen are a bit, you know, hyperbolized. For example, I've seen figures of 20%, and that's based largely on the expectation that a lot of people who are currently furloughed will eventually be made redundant, which I don't think is necessarily the case. That's my take on it.
Yeah, I agree. And I think lots of employers, when they provided furlough agreements to their staff saying the 2,500 includes your salary and your pension and our NICs, and that's about it, they try to include layoff and short-time working provisions because they anticipate the fact that there won't be an immediate return to things as normal, and they want the ability to put people back on scene but not being paid, or working reduced hours, or not working at all but still their employees. So I see that becoming quite contentious if people didn't sign their agreements or etc. And I think that there will be a culture of people perhaps agreeing to accept breaches of their contract and waiting later on to see how the market acts before trying to bring claims where they might try and argue like a final straw that there's been a series of breaches, rather than in June, July or September trying to bring a claim. Because if the, you know, if the market is decimated and it's not going to be easy for them to get a job, I don't see there being a glut of claims, because there's a saying in my industry, which is there's no point suing a straw man. So if businesses don't have money, there's no point, no matter how strong your claims are, of proceeding with them.
Yeah. You know, okay, we'll take that into account, but would you still say, you know, I would think that it's still HR best practice to have the agreement signed, even though, you know, after the initial panic, maybe the interpretation of the HMRC guidance that was released on Monday was that it's not necessarily a strict requirement. It's still best practice, isn't it?
For sure, particularly if you try to add in any additional provisions, there's a concept that if you can't prove that the employee knew what they were agreeing to, you then enter into this contentious realm where you're going to have to try and argue they must have known, or the way that they acted, they impliedly accepted it. So it's always best practice to get everything signed off and agreed.
Yeah. Okay. I think we'll actually, Fudia, stop controlling my screen.
So sorry.
I think we'll actually sign off now, if that's okay with everybody. Thank you so much for joining, everybody.
Thank you so much.
Please don't hesitate to get in touch with us. Our information is there, and our contact information is also on the Spencer West website. So yeah, let us know if you have any questions. And again, thank you.
Thank you. Bye.
Thank you.
We stop now?
I'm just going to check the chat because there's still some. Oh, thank you. That's very kind, isn't it? I'm going to end the meeting now.